hope the court has been supplied with a large plan. Which,
yes,
my
thank you,
Lord
whoever made
I
that
think
available.
the second appellant should be given the credit for that. As I indicated before lunch, I was going to look at what in EU law requires an obligation of reasons to provide, and then see how that's reflected in Article 9. In European Union law, the obligation to provide reasons contained in the directive is an essential procedural requirement, and it performs a dual function, two functions. The first is to provide those concerned with sufficient information to ascertain whether the decision is well-founded or whether it's vitiated by a defect which may permit its legality to be contested. That's its first function. Its other function is to provide the material on the basis of which the court can review the legality of the decision. If what is provided does not enable such judgments to be made, for example, because it leaves substantial doubt about the reasoning and legality, then the obligation has not been complied with and the decision is procedurally unlawful. That is why the requirement is to disclose the reasoning followed clearly and unequivocally and in sufficient detail. It's not sufficient that the reasoning may be inferred if there is no certainty that it will be accurately identified. To make those submissions good, may I take you briefly to a number of authorities? Firstly,
is that in substance any different from what Lord Brown was saying in?
Well, in my submission, it's certainly been no less than what Lord Brown was saying.
I understand that.
Yes. When one comes to look at some of the aspects of Article 9 itself, there may be some additional points I wish to make about that, but it's broadly in the same territory, if I can put it that way. Lord, firstly, on the general position, I've put in a decision of the Grand Chamber, just to set the matter out. If you could go to volume 3 of the authorities, tab 55, at page 2107. This is the case of Danska Rodri. It's a competition case, but for present purpose, if you go to page 2107, paragraph 462 in the decision of the Grand Chamber, where it says, according to a consistent body of case law, the purpose of the obligation to state reasons is to enable the court to review the legality of the decision and to provide the person concerned with sufficient information to make it possible to ascertain whether the decision is well-founded or whether it's vitiated by a defect which may permit its legality to be contested. And you'll then see that it goes on to say normally reasons are provided with the decision and a defect can't be remedied by the fact that the person concerned learns the reasons for the decision during the proceedings before the court. That's me, Sean. Well, that approach applies in the case of directives. If you would look at tab 58, which is page 2147, the case of Straybag, which my learned friend referred this morning. Its significance is at the case concerned a community institution which was then obliged to follow a directive requirement which applied to national states. So one can see how they would have approached that. So if one goes to page 2149, paragraph 2, at the time the financial regulations provided each institution to comply with the same obligations are imposed upon bodies in the member states by directives on the relevant contracts. And the relevant provision was in Article 8 of the directive, in paragraph 4 of the decision, which is that the contracting authority shall, within 15 days of the date on which written request is received, inform any eliminated candidate and tender of the reasons for the rejection of the application of his this application or his tender, and any tender has made admissible tender of the characteristics and relative advantages of the tender selected, as well as the name of the successful tenderer. If one then goes on to page 2168, paragraph 54 refers back to Article 8 of the directive, and says the Council fulfils its obligation to state reasons if it first informs the eliminated tenderers immediately the fact their tender has been rejected by a simple unreasoned communication, then subsequently, if expressly requested to do so, informs tenderers of the relative characteristics and advantages of the successful tenderer. Such a manner of proceeding satisfies the purpose of the duty to state reasons enshrined in Article 253, according to which the reasoning followed by the authority which adopted the measure must be disclosed in a clear and unequivocal fashion, so as on the one hand to make the person concerned aware of the reasons for the measure and thereby to enable them to defend their rights, and on the other to enable the court to exercise their supervisory jurisdiction. So it's applying the same approach in the case of a directive, and it has to be clear and unequivocal. My learned friend referred to paragraph 58, that you can ask for further explanations if you want, and if you get them, then they're taken into account when the proceedings are launched, but you can't rely on what's produced during the proceedings normally. If I show your Lordship two further cases. Firstly, if one goes to tab 59, which is the next tab, which is a case called Velos International SA, where again the requirements were the same about notifying reasons afterwards.
Are there any planning cases? I mean, it seems to me this is so far from what we're dealing with that it's not very helpful.
Well, I appreciate that. What I was going to do is just show you what they say about the general.
All right, no, we understand the general duty, that's pretty obvious, but what really, I mean, where we really need, is how one applies the general duty to the particular problem of a local authority dealing with a case, having regard to all the sort of practicalities of decisions of a local authority.
Well, if you
have a lot of experience, but nothing to do with these these sort of issues.
Well, if your Lordship will bear with me, I was going to take your Lordship, when I've just finished two cases on the general obligation, two cases of the Court of Justice which deal with Article 9. If your Lordship would bear with me, because so that you will then see how they relate back to these more general obligations. If you bear with me on that. Well, if I take this quite shortly, in this particular case, what had happened if one goes to page 2189, one will see from paragraph 60 that the missing information was the price which had been offered by the successful tenderer. That was what was missing. And in 61, it followed, therefore, the applicants hadn't in their possession all the elements which allowed them to understand why their offer was ranked second, and therefore the answers do not disclose clear and unequivocally its reasoning, enable the applicants to understand the justification. Then deals with the matter that you can't make it good except in exceptional cases by the matters disclosed during the proceedings, but 64 and 65 are significant about inference. It says that finding is not called into question by the argument put forward by the Parliament at the hearing that the applicants could have established the minimum price offered by one of the tenderers and the price offered by the tenderer ranked first on the basis of information available to them and deducting it through working backwards on the basis of the formula in paragraph 34 above. In that regard, suffice it to note, it is clear from settled case law that in order to comply with the obligation to state reasons, the reasoning of the author of the Act must be shown clearly and unequivocally. The Parliament's argument the applicant could, through working backwards, have deduced the minimum price offered by one of the tenderers, and therefore the price offered by the tenderer ranked first, cannot be accepted. It must be considered even if the applicants had made such a deduction, they would have had no certainty regarding the correct application of the formula and the accuracy of the result obtained. So one has to be sure, if you're going to try and infer what the reasons are, that they are indeed the reasons. And one has to justify the particular conclusions you reach. Now, my Lord, in my submission, Article 9 serves the same dual function. One of the functions is to enable those concerned to monitor the legality of the decision to grant development consent and also the environmental impact assessment which the authority has to carry out. And can I take your Lordship first, my ladies, firstly in volume 3 to tab 54, which is a case of the Commission in Spain at page 1946 it begins. And the relevant passages are at page 1956. And can I just explain what the facts were in this case? What had happened, it's a different system in Spain. The authority responsible for carrying out the environmental impact assessment is different from the authority who gives the development consent. So what had happened was they had published the environmental impact assessment, but they hadn't published the development consent. And there was an argument about whether there was a distinction for this purpose, but the court found there was. If one goes in paragraph 55, page 1956, the information to the public set out in Article 9 of the Directive takes place after the decision granting or refusing the measure has been adopted. The objective pursued by this information is not only to inform the public, but also to enable people who consider themselves to be harmed by the project in question to exercise their right to appeal within the aforementioned deadlines. And if one goes over the page to paragraph 58, Article 9 of which provides that Member States are obliged to inform the public when a decision to grant or refuse is taken, Directive 85337 amended seeks to involve the public concerned in monitoring compliance of these principles. The fact the public is only aware of the content of the opinion, which must be taken into account by the competent body before adopting its decision, does not enable it to participate in that monitoring as effectively as when the information transmitted to it relates to the final decision terminating the authorisation procedure. So it's clearly recognised that one of the functions of Article 9 is to enable those concerned to monitor the legality of the decision. The next case is a case called Solve, which is at tab 56. And in order to understand this, I think I have to explain one of the stranger aspects of the Court of Justice's approach to the Environmental Impact Assessment Directive. Your Lordship will see in the judgment that the directive does not apply to legislative acts. But the court has held that it only doesn't apply to legislative acts if you provide all the necessary information.
I think we've been there before.
In HS2, my lady, yes.
Yes.
I say it's one of the more curious aspects of the Court of Justice's judgment. If you'll, court, just bear with me. If one just goes to page 2121, paragraph 8 of the judgment, you'll see the relevant paragraph of the directive, which gave rise to the problem, which is this directive shall not apply to projects the details of which are adopted by a specific act of national legislation, since the objectives of this directive, including that of supplying information achieved through the legislative process. And what the court and what had happened in this case was there were a number of projects which had been approved by legislative process, and that's why one needs to understand that in order to understand why the question was framed as it was, because Article 9 as such wasn't directly applicable, but one had to provide the information required by Article 9, as one will see. If you can go on to 2133, which is question 4. By its fourth question, the various subdivisions of which are examined together, the referring court asks essentially whether Article 6.9 of the Our House Convention and Article 9.1 of the directive must be interpreted as precluding the adoption of legislative acts which do not themselves contain all the reasons for their adoption, reasons which make it possible to review whether the acts were adopted after an adequate prior evaluation carried out in accordance with the requirements of the Convention and the directive. It's been held that Article 4 is about screening applications to see whether they're required to be subject to the procedure. Must be interpreted as not requiring the decision not to subject a project falling within Annex 2 to that directive to an assessment should itself contain the reasons for the competent authority's decision that an assessment was unnecessary. If, however, an interested party so requests, the competent authority is obliged to communicate to him the reasons for the decision or the relevant information and documents in response to the request made. And that was significant because the directive did not impose any obligation to give reasons at that stage for the screening opinion. The court regarded the obligation to give reasons as necessary to provide an effective remedy and to monitor the legality of it, as one will see as they go further. That interpretation can be applied to Article 9.1. Thus, although Article 9.1 requires that the public must be informed in accordance with the appropriate procedures of the decision taken by the competent authority and the reasons on which the decision is based, it does not follow that the decision itself must contain the competent authorities for deciding it was necessary. It follows from that provision, however, that third parties, as well as the administrative tribunals concerned, must be able to satisfy themselves that the competent authority was aware, in accordance with the rules laid down by national law, that an adequate prior evaluation had been carried out in accordance with the requirements of the directive. Moreover, interested parties, as well as other national authorities concerned, must be able to ensure, if necessary through legal action, compliance with that obligation of the competent authority as to an evaluation. In that regard, effective judicial review, which must be able to extend to the lawfulness of the reasons for the decision being challenged, presupposes in general that the court before the matter is brought may require the competent authority to communicate those reasons. However, where it is more particularly a question of securing the effective protection of a right conferred by EU law, interested parties must also be able to defend that right under the best possible conditions and have the possibility of deciding, with full knowledge of the relevant facts, whether there is any point in applying to the courts. Consequently, in such circumstances, the competent authority is under a duty to inform them of the reasons on which the decision is based, either in the decision itself or in a subsequent communication. Now, I invite your Lordship to note the full knowledge of the relevant facts, because that is entirely inconsistent with some of my learned friends' submissions. One doesn't need to know how particular issues have been decided on the facts. Then if one just goes over to page 2134, while the reasons need not necessarily be contained in the decision itself, the competent authority may nonetheless, pursuant to the applicable legislation or of its own motion, indicate in the decision the reasons on which it's based. In that case, the decision must enable interested parties to decide whether to make use of a review procedure to contest it, taking account of any factors which may be subsequently drawn to its attention. So your Lordship will see that when dealing with Article 9, the Court of Justice has recognised that one of its main functions is to enable those interested to review whether or not the decision is lawful and whether there's a right to go to the court. And that must be based on a full disclosure of the reasons and the full facts involved, so that one can see whether the reasoning follows. And that reasoning must be clear and unequivocal. If it gives rise to substantial doubt, one won't be able to tell whether or not there may have been, for example, an error of law or whether the assessment's justified or not.
I mean, that seems to be of some help in relation to the Richardson point, as to whether there's a distinction between the decision itself and the reasons for it. It seems to treat them very much as part of the same process.
Well, it is. And if one looks at Article 9, what it refers to, as does, I think, the regulation now, you have to give the reasons on which the decision is based. That's the actual language of the directive. Yeah. In my respect, what you can't do, so far as the EIA is concerned, is to make your decision and then subsequently invent some reasons to justify it. The reasons which have to be communicated have to be those on which the decision is in fact based. Well, I'll come to Richardson, if I may, in due course. And one also needs to note, if I may, that one of the matters you need to see from 57 is that there's been an adequate prior evaluation. That's the environmental impact assessment. Yeah. That's when they refer to the prior evaluation. Now, the appellants claimed in their printed cases that only a brief summary of the main reasons was required. No explanation was required of what factual matters were accepted or rejected, why any representations or objections were rejected, or why any disputed points or substantial issues were determined as they were. In my submission, that's entirely inconsistent with the requirements of European law. Solvay makes plain that it's necessary to disclose how any factual issues were determined. That's perfectly plain. Failure to explain why the substantial issues were in fact determined by the authority as they were will be inconsistent with the general purpose of the requirement to provide reasons, which is to enable the reasoning to be reviewed properly. And a failure to explain why objections had been rejected would also be incompatible with one of the particular functions of Article 9 under the directive. Your Lordships may recall, when I showed you the directive before lunch, subparagraph B refers to the reasons having been framed in the context of the representations and objections which have been made during the process. And indeed, Article 8 requires due account to be taken of them. And that's significant because the directive is one that provides for a process which is designed to enable the public and other authorities concerned to participate in the decision-making process, and to do so effectively and in a transparent way. So if your Lordship would just go back to volume 1 of the authorities at page 1134. I haven't taken your Lordship through all the provisions of the directive. I'm sure they'll be generally familiar. But if I could just draw attention to Article 6.4 on page 1134. The public concern should be given early and effective opportunities to participate in the environmental decision-making procedures and shall be entitled to express comments and opinions when all opinions are open in the competent authorities or authorities before the decision is taken. And Article 8 requires, over the page 1135, the results of consultation that includes with other authorities and information pursuant to Articles 5, 6 and 7 should be taken into consideration. And therefore, one can see also in Article 9b the reasons having to be framed, having examined the concerns and opinions expressed by the public. So one of the points of this particular directive is to ensure that the public are engaged, their comments and opinions are taken into account.
There's no dispute about that in this case.
Well,
the officer's report hasn't been criticised as such, as I understand.
No. The point I wanted to make is my learned friends contend.
Yes, I know that's what they say.
I think it's important that
we need to start here from the basis of what, I must say, to my mind, is an extraordinarily impressive report by the officers, which does go through all the consultations, the considerations, the issues. And had the members adopted that, I doubt if anyone was saying that was an inadequate statement of their reasons. The problem comes because they didn't. Yeah. And what we need to know is what they have to do in that case.
So, exactly so, my Lord.
And you're not suggesting they then have to do a rival report of 200 pages.
No, the reason I was addressing it is because a submission was made to your Lordship.
No, I understand.
And I thought it right that I should make a perfect plain that that's.
And for my part, I've got the point.
Can I now deal with the normal consequences of a failure to provide a statement? Article 10 of the directive requires that both the substantive and procedural legality of a decision must be open to challenge. But what it doesn't do is to prescribe the remedy to be granted when it's found to be unlawful, whether procedurally or substantively. That's a matter for national law, subject to the requirements of equivalence and effectiveness. And in my submission, equivalence is relevant in this case. National law provides that where reasons have to be provided together with a decision under a statutory provision, evidence is only admissible exceptionally to remedy any deficiency, and that the normal remedy is to quash the decision. And I take you briefly to two cases to make that point. Firstly, a judgment of Lord Justice Dyson, as he then was, in a case called Hijazi, which is in volume 1 at tab 28. At page 1378, to begin with, if I may. This was a homelessness case, and the relevant statutory provision is set out in paragraph 4 of Lord Justice Dyson's judgment, which provided, on completing their inquiries, the authority shall notify the applicant of their decision so far as any issue is decided against his interests, inform of the reasons for their decision. So that was the relevant statutory provision. If I can then invite you to go to page 1385, paragraph 31, this is under the heading about whether a statement should have been omitted. There's been a good deal of authority on the question of whether and in what circumstances a decision maker may, in the context of a legal challenge decision, supplement the reasons he gave for his decision at the time it was made. But in my judgment, for the purpose of this appeal, it's not necessary to travel beyond the decision of this court in Ermakov in what has come to be regarded as a classic exposition of the relevant law. Lord Justice Hutchinson reviewed the authorities comprehensively in the context of a homeless housing appeal, and the essential part of his judgment, for present purposes, appears in the passage starting at page 315H. The court can, in an appropriate case, should admit evidence to elucidate or exceptionally to correct or add to the reasons, but should, consistently with Lord Justice Staines's observations ex parte Graham, be very cautious in doing so. I have in mind cases where, for example, an error has been made in transcription or expression, or word or words inadvertently omitted, or where the language used may in some way be lacking clarity. These examples are not intended to be exhaustive, but rather to reflect the view that the function of such evidence should generally be elucidation, not fundamental alteration, confirmation, not contradiction. And then he goes on to deal with what you shouldn't put in. And then at the top of the page, I should say, in my view, it's not, in my view, permissible to say merely because the applicant does not feel able to challenge the bona fides the decision-maker's explanations, the real reasons, that the applicant is therefore not prejudiced, and evidence as to real reasons can be relied upon. This is because I do not accept that it is necessarily the case that in that situation he is not prejudiced, and secondly because in this class of case I do not consider it is necessary for the applicant to show prejudice before he can obtain relief. Section 64 requires a decision at the same time reasons, and if no reasons, which is the reality of a case such as the present, or wholly deficient reasons are given, he's prima facie entitled to have the decision quashed. There are, I consider, good policy reasons why this should be so. The case is emphasised that the purpose of reasons is to inform the parties why they have won and lost, and enable them to assess whether they have any ground for challenging an adverse decision. To permit wholesale amendment or reversal of the stated reasons is inimical to this purpose. Moreover, not only does it encourage a sloppy approach by the decision maker, but it gives rise to potential practical difficulties. In the present case, it was not, but in many cases it might be suggested that the alleged true reasons are in fact second thoughts designed to remedy an otherwise fatal error exposed by the judicial review proceedings. This would lead to applications of cross-examination and possibly for further discovery, both of which, while permissible in judicial review proceedings, generally are regarded as inappropriate. Lord, can I then also take you to a decision of the Court of Appeal in a planning context?
Ermakov is, of course, very familiar and is very often cited in this context. Has it ever actually been approved in this House or in the Supreme Court?
I don't think it has. From the investigations I've seen, but it's obviously been followed because it's been regarded
no, I'm not
as
saying it should be, but I'm just interested to know whether it is, in fact.
I have to say I'm not aware of a case in which it has been.
Okay, thank you.
Can I show another decision of the Court of Appeal, this time in planning, which is McRae, which is in volume 2 of the authorities, tab 30, at page 1407. And this was a case about the requirement to provide summary reasons for the grant of planning permission. And if I could take you in the judgment of Lord Justice Sullivan to page 1412. And might I invite the court to read from paragraph 23 to 28. And could the court also note paragraph 40 in relation to my learned friend's suggestion one might now get the members to produce a statement. This is in Lord Justice Pill's judgment about some of the practical difficulties. It's page 1415. Lord, I do need to take you to Richardson, which is in volume 2 of the authorities at tab 44, which is, begins at page 1739 of the electronic bundle.
Sorry, which reference?
It's volume 2, tab 44, it's page 1739, where the report begins. And although I'm going to address the principle on which the decision was based, it is perhaps right to note what the factual position in this case was, which was that before the decision at first instance, which was for Mr. Justice Stephen Richards at that stage, the authority had produced a statement, and it had a number of witness statements from their members, which went to support what that statement said, which they were proposing, if the court thought it appropriate, then to lodge. And both Mr. Justice Richards and Lord Justice Simon Brown found that the statement which had been prepared reflected what the members had in fact thought at the time. So that's the factual background to the case. However, so far as the principle on which my learned friends rely, if I could take you to page 1754. The argument which the court was addressing is set out in paragraph 38, which was Mr. McCracken's argument that the court is simply not permitted to regard a breach of the implementing regulations as curable other than by outright quashing. I don't go that far. I simply say that's the normal remedy, quashing, but that was what the submission in that case actually was in that case. Then the critical part of the judge's reasoning is picked up just above letter F, by Lord Justice Simon Brown. The critical part of the judge's reasons I conceive it to be is that expressed in paragraph 49. Regulation 21 looks to the position after the grant of planning permission. It's concerned with the making of information available to the public as to what was decided and why it's been decided, rather than laying down requirements for the decision-making process itself. And if the court be good enough to read paragraph 39, and you'll see how Lord Justice Simon Brown effectively endorsed that approach.
That was, of course, as you say, before the amendment of the directive.
Yeah, and it's right to say the principles of equivalence weren't drawn to the court's attention. It was treated simply as a pure domestic law case in this particular area. And as I say, nothing seems to have been made of the point that the directive actually refers to giving the reasons on which the decision is based.
But you make an additional point that equivalence would require that anyway, if that's what happens under domestic law.
Exactly so. But if the court could read paragraph 39, that would be good. In my submission, there's a rather short point. Where reasons have to be provided, they have to be the reasons which actually inform the decision. And as a matter of fact, if you communicate the decision with the reasons, that always takes place subsequent to the decision being taken anyway.
I'm sorry, I didn't hear that.
If you communicate the decision and the reasons, which is what you do with the statement at the same time, that always follows when the decision has in fact been taken. You can't communicate something until you've actually done it. In this case, made a decision. And that has to be done. If I may say so, the analogy with a judge, my respect submission, isn't a good analogy. As the court know from one of my latest judgments in LB Children, a judge can announce the result, which is come to for reasons to be given later, but go back and change that at any time before the order's sealed. That's possible to do. In this case, once you've announced you granted planning permission, that's it, your functus as a local planning authority. You can't then think about the reasons why you've done something and change your mind. And I'll also submit that the Court of Appeal failed to appreciate the underlying purpose of the requirement to give reasons, which is to enable one to review the legality of the decision. If you could simply provide a statement later, that would undermine the purpose, which is to enable the parties who receive the statement, which tells you what the content of the decision is and the reasons, to decide whether or not to review it. If the position was that you could simply produce a statement later, you could, there'd be no reason why you shouldn't produce evidence of that in the judicial review proceedings, with all the problems that may well entail. In my respectful submission, it undermines the point of the requirement to say that normally all you'll need to do if someone comes and complains is issue a statement later. My Lord, my learned friends refer to the West Kensington Estates Tenants and Residents Association case, which for your Lordship's notes were in volume 4 at tab 5. I accept that the court isn't compelled to quash it. My contention, that's the normal remedy. Mr. Justice Lindblom was not directed to the relevant case law on failure to comply with the statutory obligation to give reasons and the requirements for equivalence. And his decision was based on the notion that no one had suffered substantial prejudice in that case. And in my submission, that's not so here, for the reasons I shall give. Can I then turn to the reasons, such as they are? I'm sorry to deal with that first. And I'm going to concentrate on the question about the area of outstanding natural beauty. And effectively, your Lordships will have noted that what the appellants what the court is now being invited to do is to look at 4 documents to try to elicit them. There's firstly the officer's report in June 2013, the minutes of the meeting, then the report in December 2014, and the minutes of that. And the public is supposed, instead of having a statement which actually sets everything out clearly, to hunt through those documents to try and elicit the reasons for this decision in a way which complies with the directive. In my submission, that obviously frustrates the whole purpose of the statement. But as I say, in this case, the officers advised, amongst other matters, that the application had to accord with the policy in the MPPF about areas of outstanding natural beauty, and it was central to the evaluation of the application. Can I just give you the 2 paragraph references without taking it up? Which is paragraph 212 and 2.439, which is Core Bundle 2, tab 11, pages 411 and 488. Can I ask you to take Core Bundle 2 and look at the overall conclusions again, if I may. First at page 491. First in paragraph 2.450, where they said, while the proposal would conflict with development plan policy, The conclusions of this report are that subject to the implementation of the composite scheme, I'll come back to that, and through the use of planning conditions and obligations, the application should be capable of complying with national policy relating to major development within the ANOB and development affecting a national heritage asset. And 2.454 is that on balance, the application would, as a single comprehensive scheme, I'll come back to that again, support rather than work against objectives. Mr. Cameron referred you to paragraph 2.456 on page 492. And can I emphasize a number of the conditions? Firstly, that the hotel should be phased so it's provided as part of when FLB is provided. That was to ensure the economic benefits were provided on which the scheme depended, and I'll come back to that. The other was the reduction in housing quantum and density at Farthing Low, and the setting back of development of the southwest periphery. Now, those were two potentially separate matters, because if you go to 2.457, when the members were asked to consider whether planning permission could be justified without one or more of the conditions recommended, said based on anticipated concerns, the committee might consider what, if any, what scope, if any, might exist to increase the residential density on, say, FLC from that recommended to account for the safeguarding area. So one way of dealing with this, without affecting viability, would have been to protect the safeguarding area, but increase the density on FLC. And I'll come back to that. And it's also important to notice the terms in which the final sentence is framed. It's the officer position, as set out in the report, well-founded, and that all of those matters are necessary to deliver the right composite package, including the economic benefits, so that, on balance, a recommendation can reasonably be made, which is an important indication of the strength that they're feeling about each of those matters. Now, in the event, the only one which was actually required was the graduated payments, as far as one can see. The other requirements weren't. Now, if I can ask you to go to the minutes to begin with. Page 539. The committee was addressed first.
Where do we find the graduated payments being accepted?
I'm sorry, in the resolution. Sorry, if you will just bear with me. If you go to page 544, this is in the resolution. Under A, little Roman numeral 3, little Roman numeral 1, you'll see the various payments set out. Which
So I'm sorry, Mr. Howell. Phasing.
Phasing.
Was the committee departing from the recommendation about phasing?
Yes, they didn't.
In what respect?
Well, one of my submissions. Sorry, no, not about phasing the money. Sorry.
No, quite.
No. My point was, I think that they accepted that.
They did.
Yeah, they did.
And that was to be picked up in the Section 106 agreement.
Yes, indeed.
And was picked up.
I assume so. Yes, madam.
Thank you.
I'm sorry. It could.
But not the phasing of the hotel to the development.
No, not phasing the hotel. What was picked up in the 106 was that if it was going to be if it was to be a hotel, it was going to be a high-class hotel. If one goes to page 539. Members were addressed by the Head of Regeneration and Development, and it's significant to note what he said at the end, which the first paragraph, it was incumbent upon members to consider whether material considerations indicate that nonetheless permission should be given, and in particular, whether the heritage and economic benefits of the proposed and the additional housing outweighed its harmful impact on the environment. So it appears to be suggesting a simple balancing exercise. And when one comes to the members of the committee, at page 542, one should note that the passage in the minutes upon which my learned friends particularly rely is the consolidated report of what Councillors Gowan, Walkenden and Walker said, who are only 3 of the members. And the reason they concentrate on those 3 is that those 3 are the only ones who appear to conduct any balancing exercise looking at the harm to the ANOB. So if one looks at what they say, having set out a number of advantages, including the hotel, they said it was felt the application should not be restricted.
Sorry, could you remind me what page you're on?
Page 542, my lady.
Thank you.
I'm sorry. This is in Cowan, Walkenden and Walker.
Yes.
It was felt the application should not be restricted in the way proposed in the recommendation, as this could jeopardise the viability of the scheme, deter other developers and be less effective in delivering the economic benefits. The committee had to assess whether the advantages outweighed the harm that would be caused to the ANOB. When seen from the ground with effective screening, it was believed this could be minimised. In these exceptional circumstances, considered the advantages did outweigh the harmful impact on the ANOB. Now, they plainly thought that the effect on the ANOB could be minimised as a result of screening. Now, what is said there would fail to provide the information which would be required in any statement for the ANOB. And to understand why, can I just invite you to look at a bit of the background and then explain why it wouldn't. Firstly, the ANOB executive. Now, the ANOB has all the authorities, local authorities, participate in a body which is the ANOB executive. That's what they do. And if you would, their representation is at tab 9. If you would go to page 324 in their representation. Where they were dealing with landscape and visual impacts. Page 324, electronic bundle. At the bottom of the page, it is important to understand the role of tree planting in the application in relation to the impact of the Fatting-Low scheme on the character of the area and on the visibility of the scheme. Comparison of the area at present with the proposed...
Sorry, I'm not with you.
Page 324, my lord.
Is that in the electronic bit?
Page 324 in the electronic bundle. It's in the... Your Lordship got them?
Yes.
Comparison of the area at present with the proposed master plan shows no new screening planting plan is proposed. Structural planting is confined to thickening up the woodland on the higher valley slope to the south and to planting within principally the north-south corridors inside the development break up the urban mass. Neither of the latter will perform a screening function. The overall scale of tree planting is limited to these few specific purposes. We should observe this commentary on the proposals is not a criticism. Where the sweep of open chalk sides and ridge tops is an important feature of the ANOB character, inserting screening belts would damage that character. We commented at the pre-application stage that the tree screening would be out of character to the open chalk valley. So there are two issues when one's looking at screening. One is it effective in screening development? Secondly, is the screening itself harmful to the ANOB? Now, if one then goes to the report itself, first at page 437, paragraph 2.155 says, to the west of FLC, the valley opens out and the landscape difference between the two sites becomes distinct. FLB sits proud of the B2011 valley floor on land between 60 and 80 metres AOD with a maximum illustrative elevation of 95. It reads as a protrusion to the valley side and moving east to west appears progressively more visually prominent within the open landscape. FLB is clearly seen from high views. The elevated and exposed nature of the southern and western extremities of the site, in particular, enables it to be seen as an integral part of the open ridge valley landscape. And then over the next page, 438, at 2.162. The applicant refers to woodland planting being introduced to the west of FLB to part screen this area. Even with a substantial increase in the area of planting, however, the change in levels east of any planting would mean that over time screening would still be largely ineffective. Now, If one was to comply with the requirements of the directive, there are three things which would have had to be done. Firstly, the statement requires a description of the mitigation measures to be included in the statement. As your Lordship will recall, there's a specific requirement. I won't go into why there's a process for leading to do that. But what would have had to be said is what the screening envisaged by the members actually was. Was it more than what the application envisaged? The officers considered the position with a substantial increase. What screening were members considering? Secondly, the statement would have had to identify and describe the effect which it was thought that the development would have on the landscape, taking account of that screening. That identification and description is required by Article 3 of the EIA Directive. If I could just ask you to briefly go back to Volume 1 of the authorities at tab 17, it's page 1133. Article 3, the environmental impact assessment shall identify, describe and assess in an appropriate manner the direct and indirect effects.
Which page again?
Page 1133.
113. Thank you.
Article 3, the assessment has to identify, describe and assess in an appropriate manner the direct and indirect effects of the project on the following factors, and then in B, the landscape. And that is an assessment which it is, of course, for the competent authority, in this case the Council, to carry out. And in reaching that conclusion, it would have had to be addressed whether or not the screening belts were themselves harmful to the ANOB. Now, the effect on the area of outstanding natural beauty was patently one of the main considerations in the decision. And of course, the statement has to include not merely the reasons, but also the considerations which, on which the decision is based.
What's the difference?
Well, the reason in my submission why it's there, it's also in the convention,
Yes, quite.
is because the structure of both the convention and the directive is first you have an environmental impact assessment, so you work out what the effect on the environment will be, and then you take that into account as a consideration in deciding whether or not to give development consent, in this case planning permission. So the conclusion of the environmental impact assessment will be the consideration, some of the main considerations which you take into account. And that's reflected, you'll recall, in the Solvay case, in paragraph 57, where it says you have to be able to see whether there's been a proper environmental impact assessment having been carried out. So in my respectful submission, what the statement would have had to do would have had to not merely say what the screening was, because that would be the mitigation measure, have to itself identify and describe what the resulting effect would be. All we've been told is it's minimised. And the third reason why you would have to identify that is that you need to know or formulate clearly what the harm to the ANOB will be in order to decide what goes in the balance on that side. True it is, the NPPF says that great weight has to be given to the harm to the ANOB in paragraph 115, but plainly the extent of the harm must be a particularly important consideration when one's considering whether or not to grant development consent. And so some assessment, rather than simply saying is minimised, whatever that might mean, would need to be given. And what's also plain from this is the appellant's contention that the members simply adopted what the officers had said about the environmental impact, in my submission, can't be sustained. It's plain that they took a different view of that. Now, this morning, the appellants have referred to the report in December 2014. And in my submission, that doesn't help their case at all. The relevant part on landscaping is in page 607. I'm not sure if your Lordship has the electronic bundles or the hard copy one. This is in part 2 of the appendix.
607, did you say?
607. It's page 357 if you want the hard, in the bottom left-hand corner.
Sorry, part 2 of the appendix.
It's part 2. It's page 607 electronically. If you haven't got it, it's page P357.
Thank you.
I'm sorry about that.
And it's paragraph,
144. It's the last sub-part of paragraph 144. This is about the landscape impact. It refers, the committee took into account the potential for effective screening. In this respect, Section 106 proposes a structural landscape area, the extent of which is shown on Plan 8. And that's all there is. That's all there is. There's no assessment of to what extent that will screen the development and from where. No assessment of whether that's in character with the ANOB and would itself be harmful. And that's all there is. Effectively, all that's happened is because members referred to screening, officers have gone away and found something for it. I'd like to look at 3 of the requirements. The first is about the safeguarding area in FLB. If I can ask you, you'll find the areas at page 533 in the appendix. I don't ask you to go back to that, it's in the southwestern corner. One goes to the reason for the proposal is that is where officers thought the landscape harm would be most acute. That was in paragraph 2.216 on page 447. Now, the effect if you go to page 372, the comments from the Council's Principal Ecology Officer under Fathinglow Landscape.
This is the 312.
372, man.
370.
Sorry, this is in the report.
Thank you.
This is from one of the Council's officers, the Principal Ecology Officer, dealing with the landscape at Farthinglow. The last of the bullet points, the reduction in development in FLB, as indicated in Appendix 5, would substantially diminish the harm to the NOB. So it was of itself a significant matter, simply the safeguarding area. Now, as I've indicated at page 492, in paragraph 2.457, the committee were invited to consider whether you could compensate for the reduction in development on B by increasing the density on C. So Your Lordship will see. Now, the position about that, if we go to page 438, in paragraph 2.158, is that the overall density was 36 dwellings per hectare. Within FLC, the density is 34, whereas on the more visually sensitive FLB, this increases to 41, whilst for the purposes of density calculation, the care home is it's not strictly residential. The inclusion of these 90 apartments would increase the density to 48 or so. So ultimately, the committee were quite happy with a density of either 41 or 48 on FLB. So they plainly would have, in my submission, could have contemplated the possibility of increasing the density on FLC to compensate for any reduction, which is what the officers invited them to do. Now, there is nothing whatever in the minutes to indicate that option was considered at all. It's not something upon which, so far as one knows, BNP Paribas actually commented at all. And there's no reason why the viability of the scheme should be adversely affected if there was a compensation by increasing the density on FLC. The other reasons given on page 540 page 542, that it might deter other developers. It's not clear why that would deter any other developer. And why it will be less effective in delivering the economic benefits is equally mysterious. In my respectful submission, if the members did address the question, as they were invited to do, they've given no reasons about what conclusion they reached, and it's not clear whether or not they did address that particular issue. So in my respectful submission, the first of those requirements, which is not affected by viability, in my respectful submission, simply there's no adequate reasons to deal with it at all. Can I now turn to the question of the reduction in density overall, where my learned friends simply say, well, that's a question of viability. Moderation, the officers said, was a fundamental consideration to this application. That's paragraph 2.212, page 446.
By
2.212. Sorry, there are too many numbers. It's at page 446. I've given the wrong one, sorry. I'm just, sorry, it's 210. It's the last part of 210, where they say the scope to moderate the harm to the MP, this being a fundamental consideration under the NPPF policy, as your Lordship will see. I'm sorry, it's paragraph 210. Now, if I'm going to ask you to go to 489,
Paragraph?
2.443. Where they say this: a considerable moderation of the harm could be achieved by reducing the density of development and safeguarding the areas. This would reduce the amount of housing at Fadlingo to approximately 365 units. Advice from the Council's viability advisor indicates that, subject to a reduction in the code from 4 to 3, this would deliver a viable development capable of providing the same range of monetary contributions as currently proposed. I invite the Court to look at the next sentence particularly. It would also achieve a more marketable and higher quality housing scheme than that illustrated on the submitted indicative layout, this being important to diversify and improve the Dover's housing offer. A lower density development would also be necessary to a limited extent, would also reduce to a limited extent the level of payments required to support the necessary infrastructure. And then if one goes to 2.445, one can see the importance which those moderating matters had to the recommendation. But what is important to note is the comments about the low density scheme being more marketable and of a higher quality. The Council had two advisors advising them about such matters, Smith Score and Wessex Economics. And if one goes back to page 442, paragraph 2.179, and first defines what Wessex Economics was saying about the proposed scheme. It's at 2.179. With regard to how the scheme is likely to fit current market demand, Wessex Economics is not convinced the non-traditional housing design as shown would have wide market appeal. Smith Gore also state the inclusion of flats comprising 24% of the total numbers would be totally against current market requirements. Should more housing emerge through any details in place of flats, this might suggest the quantum of residents currently sought is too high. So that's, and then if one goes to 2182, Smith Gore also comment the flat grass roof modular buildings pay little heed to current market and are unlikely to be built by a national house builder. So what one has, if one goes 2213, if one goes on to page 447, what the officers said about the current scheme. Paragraph 2.213, should be also noted the current advice provided to the local planning authority indicates the current scheme would not be of interest to a national house builder and will probably not be marketable. So the The actual viability of the existing scheme, which they were being advised about, was that it probably wasn't viable. And the officers, as you'll see, went on to say that actually it wouldn't produce the higher quality housing scheme which Dover required. Now,
what was the evidence of what the second appellants were going to do with it? Well, they weren't going to develop it themselves.
They were not proposing to develop any of it themselves, as far as I understand.
But was there evidence about how they proposed to market it all? I mean, don't worry if you don't know the answer.
I don't know if
the officer's advice was that the thing wasn't marketable. Yeah. Was there advice from someone saying it was? Or?
Not the council. BNP Paribas. They said it was, yes. But the point I'm getting to is that when you look at what the committee actually did with this, we have to go back to page 540. All they were told on viability was that a lower density scheme would turn a positive land value into a negative value. It wouldn't be able to... Page 540 in the minutes. Page 540?
540.
540.
Where's the, I mean, BNP Paribas had presumably given some other advice earlier on about the general viability of the scheme.
Yes. There's some reports on that in the second bundle.
Can you give me the reference without necessarily taking me to it?
Yeah, there's... can I give you the P number? I haven't got the electronic bundle.
Yes.
It's P428, Assessment of Economic Viability.
Okay. Thank you very much.
And there's also a report from Smith Score. Yeah, and so forth. But
that's the main BNP Paribas.
That's the main one, yes.
Thank you.
Mr. Howell, the more you go on with these intricate and important points flagged up by the officers, one has to ask, the calibre of the councillors in Dover is not in issue. However high their calibre, how could they address all these issues at a meeting beginning at 6 o'clock?
They're charged with determining the application. That's the first point. But obviously, what they would need to do, if they need more time, they may have to have a further meeting about it, if that's what was necessary.
Do you think that in the light of the very late contribution of BNP Paribas, which carried so much weight, and the responsive denial by Smith Score, the planning officers should have said to them, well, in the light of this, it's not reasoned, but you've got this big dispute on viability. You may think that you're not in a position to decide this tonight.
And in my submission...
Might that have been done?
Yes. It's perfectly possible for an officer to say, in the light of the latest information, we think you should adjourn to consider the matter further. That's a perfectly acceptable approach. And
Wasn't even the only item on the agenda, was it?
no, there is. Sorry, Manager reminds me that there is in fact a code of practice for members which tells you what to do if you feel you haven't got enough time. It's in volume 3 of the authorities bundle, at page 2234. Perhaps one ought just to look and see what it is. If you go to page 2227, this is 2227. This is a model code produced by lawyers in local government. And you can see from the second paragraph, the drafting of this model code was subject to consultation and comment from a number of local authorities through the machinery of the Association of Council Secretaries and Solicitors, who are now the LGG, Local Government Association, Local Government Ombudsman, Audit Commission, firms of solicitors, and so forth. And we understand Dover has adopted this as a code as well. But if one goes to 2234, in the third bullet point to deal with the point my Lord Wilson was making, It says, do come to your decision only after due consideration of all the information reasonably required upon which to base a decision. If you feel there is insufficient time to digest new information or that there is simply insufficient information before you, request that further information, if necessary, defer or refuse.
Thank you.
Well, page 540 in the minutes. All that members were told, effectively, was that the positive land value would be turned into a negative land value. They were told their own expert advisors didn't agree with that. What's striking about the minutes is it appears that members made no attempt, as far as one can see, to investigate why BNP Paribas thought that would result, why their officers and their advisors were not persuaded by it. They seem to, as far as one can see, there's, one cannot tell from the reasons whether they had any basis for believing there was a material risk to viability. Because until one actually understands what the issues are and why their own officers and advisors didn't accept what BNP Paribas was saying, one can't make a reasoned judgment about the risks. Now, it may be that they did investigate that, but the minutes don't disclose that. And in my submission, if one's going to provide reasons, one would need to explain why, on this particular point, which is a crucial point in terms of the ANOB, that there was felt to be a sufficient material risk to the scheme.
Is it right that I see that the report was sent out on the 7th of June 2013, so 6 days before the meeting?
I'm not sure that's quite right, no, but it was
Well,
short,
I just
short
look
for
at
the
page
long time.
354.
Yeah.
So they didn't have very long to absorb all this.
It was a 173-page report, which is quite a long
But
report.
presumably this was the culmination of a debate which had been going on for some time within the council.
Well, I'm not sure.
Well, I mean, you're not the right person to ask.
Right, but, yeah. And one of the points I emphasised about the marketability and the advice which my learned friends say that you can take it that the members of the committee agreed with the officers' report and their advice unless they say otherwise. They have not said otherwise here, that they rejected the advice they received that the proposed scheme would not be unlikely to be marketable. They don't say that they rejected their officers' advice that a lower density scheme would be higher quality, which of course would potentially make it more marketable. One simply doesn't know what they made of their own officers' advice on those matters.
But we know, of course, that the actual decision wasn't taken until a year and a half later, in December 2014.
That is true.
And but at that stage, it seems that the 2013 decision was treated as not reviewable.
Well,
So there's no, I mean, I'm just wondering whether it would have been possible to say, well, we need more time. Yes, the answer is yeah.
well, there would be nothing to stop them saying we're minded to grant permission if we can be persuaded that the scheme would be unviable unless it's in the form applied for, and come back and tell us about
We
that.
want more information about the difference of view about the viability of the officer's recommendation.
Exactly. Well, can I say something about the hotel as well? I'm conscious of the time. I would like to say something, if I get an opportunity, about the common law more generally. But if I can try just finishing off the hotel.
It's up
first.
to you what you spend your time on, Mr. Hull.
I'm hoping to be of assistance to the committee. But,
So the hotel.
the hotel. Now, the justification for the scheme depended on the economic benefits at Western Heights. And these envisaged the provision of an 130-bed hotel and a 150-person conference centre. And that would provide a tourist attraction, and it would provide half of the full-time equivalent jobs involved in the application as a whole. Can I just give you the references for that? That's paragraphs 211 and 212 at page 429. Now, the report made plain that the harm to the ANOB will be disproportionate without suitable outcomes being achieved at Western Heights, and that the development of Fathering should be tied to the provision of the hotel. If we could go to page 448.
Paragraph.
448. Paragraph 2.221, right at the bottom of the page. Harm to the ANOB would be disproportionate and difficult to justify in planning terms should FLB be developed without suitable outcomes being achieved at the Western Heights, which support the exceptional planning case. And that's why they recommended that some development on FLB be tied to progressing the hotel at Western Heights. And if one just goes back for a moment. The importance which the officers attach to the actual delivery of these matters as part of the composite development. If one goes back to 433,
Paragraph.
para 2.130, they made the point that to give weight to the claim benefits, there must be reasonable certainty they will actually be delivered, as your lordships will see. And one of the matters which your lordship will see in 2.131 at the top of page 434 was the phasing of the hotel to a development phase. And if one then goes to 2.134, the on-balance officer view is provided those above are addressed in full, then there should be sufficient certainty that significant benefits would accrue. However, if one goes back to 2.115, where they considered the position if there wasn't the tie, they said this at 2.115, that the applicants didn't wish the delivery of the heritage works of the hotel to be phased. This would mean that while the permission could be given for the drop redoubt heritage works in the hotel as part of the application, there'd be no actual requirement for these to be carried out should residential development be commenced. This introduces a substantial risk that the planning application would not be able to guarantee the delivery of the main economic benefits intended, in large part to justify the approval relative to the stringent NPPF tests. Approval of the application under these circumstances would be extremely difficult to justify. As outlined below, this risk of non-delivery is greatest in respect of the hotel. And at 431, paragraph 2.122, they say the wish of the applicant not to link the hotel to the implementation and completion of the other development subject to the application in effect means that the delivery of the hotel could not be guaranteed. In these circumstances, it would not be possible to give the potential economic benefits associated with the hotel, which are identified here as being very important to the overall economic case, anything more than very limited weight as a material planning consideration. Now, Lord, the position on the hotel, if one goes back to page 540,
Paragraph.
It's page 540, it's in the minutes, my lord. So it's
Minutes.
I'm sorry. Phasing was not dealt with as part of the objections on viability. You'll see that it's in the paragraph following the position on viability, where they say, in terms of phasing, the applicants have raised concerns over the recommendations by officers that the construction of the hotel should be phased in with the Fathling development. It's argued that the hotel operator would be looking for assurance that heritage improvements at Western Heights were progressing before making the decision to invest. To delay housing construction at Fathling when it was this element of the scheme that would fund the heritage improvements at Western Heights was illogical. Moreover, delaying development of Fathling B until Fathling C had been completed was the delivery of the heritage payments. On the first point, officers were of the view that the delivery of 3.4 million would make a significant contribution to investor confidence. That was when they were going to come in normal phasing. And on the second, the heritage payment, if made when 80% of the development was completed, would be late in coming forward in any event. So the officers didn't accept those points. Now, let me assume for a moment that members had reasons for rejecting it. we'll see in our printer case we've dealt with that and so but didn't. What's crucial about the position at 542 is that members did not consider that if the hotel was not linked to the development, what weight it could be given. Because they were told that very limited weight could be given to the benefits of the hotel if there was no guarantee that it was going to be provided. But there's no consideration, or if they did, there's no reason why that should be given any significant weight once they decide that it's not going to be linked. Can I now move on to the implied duty? I've got a little time.
Yes, you've got a little time. You've got about
Well,
quarter of an hour, just about.
it's really another appeal in reality, but that's a different issue. As the court will have noticed, there is now an obligation to provide reasons for planning decisions in all cases where officers take the decision under what's called the openness regulation. So officers take decisions under delegated powers in 94% of all cases.
I imagine they're very short. Or
Well,
are they? I mean, maybe, it'd be rather interesting to know what they look like. In fact.
Well, I can tell you one I have actually seen, which was effectively what happened was one officer produced a report for another officer to look at.
Yeah.
So,
But I mean, don't.
Yeah.
You know, I don't really want anecdotal material.
No.
You know, what I would like our help on, as someone who has enormous experience, is what would be enough. Because I think whatever we say, even accepting your points, we will not want to over-egg the pudding and put a completely unacceptable weight. And what is said to against you is, well, you know what their reasons were. They decided, contrary to the officer's advice, that the risk of losing this very, very important scheme was too great to justify. Now, that was their reason. I mean, they could have expanded it, but you know what their reason was. Now, how much further do they have to go than that? Do they have to produce a 30-page sort of screed dealing with all these things? And if so, how do they get it through committee? And these are the practical points which I think we would like our help on, at least I certainly would.
okay. Well, the position, firstly, in my submission is that the public are entitled to know why the decision has been taken as it has been, just as much when a local planning authority takes the decision as when the Secretary of State takes a decision. They're entitled to know. In my respectful submission, Lord Justice Laws was correct in that. The position about what level of detail you may have to go into is invariably dependent on the context of the particular decision which you're dealing with. So when one's dealing with a decision such as this, which on any scale is at the more complicated, detailed end of the matter, what one would require by way of reasons to justify the decision, bearing in mind it's contrary to the development plan, it raises a major development, it's an unprecedented scale.
If we know all that,
Well,
if you're advising the council, faced with this situation, what do you tell them to do?
Well,
you might say set up a subcommittee to come back with a report or something.
Well, what they need to do is to agree on the reasons why they're disagreeing in practice with the officers in this particular case. And
Well, the officers could provide a list of the points on which you seem to be disagreeing.
yes.
And then they might supply some reasons for doing that.
In practice, what happens is if members are minded to disagree with officers, I mean, the same problem arises if they propose to refuse a permission which officers recommend should be granted. They have to provide reasons at that point. What they can do is, if there's been a debate, they can adjourn, they can ask officers to draft something for them and to help them formulate something, and they can then vote on the reasons if that's how they wish to do it. And there'll be nothing to stop them saying, for example, that they agree with the analysis and the report subject to the following qualifications, if that's what they wish to do. Where there are specific issues, for example, the safeguarding area, they could say why they rejected that. It shouldn't take long to say why they rejected it, and if they thought about it. So far as viability is concerned, that would depend on what material was available to them. If the position is that their officers are saying this is viable for this reason, but BNP Paribas disagree with that, and these are the reasons, they may have to form a judgment about that.
Yeah. Is there any guidance on this? I mean, you referred us to the local government guidance.
Yeah, yes, if you, there is in fact a little bit about what they should do if they disagree with officers in that. If I could show you that. That's in volume 3. If you go back. It's page 2234. This is the last bullet point above 11 training. So 2234, my lord. It says, do make sure if you're proposing, seconding or supporting a decision contrary to officer recommendation or the development plan, that you clearly identify and understand the planning reasons leading to this conclusion. These reasons must be given prior to the vote and be recorded. Be aware that you may have to justify the resulting decision by giving evidence in the event of any challenge. So they are, members are encouraged to give any reasons prior to the vote and ensure they're recorded.
Right.
My Lord, can I then, I won't have time to deal with the implied duty, but say something about the standard of reasoning, which is what I think Lord Carman's mainly concerned with.
It's the
Lord,
practicalities, really.
No, I appreciate that. My Lady, in my submission, a large number of the points which Mrs. Justice Lang gave in the Hawksworth decision are not persuasive in terms of how one should approach this. In my submission, she draws a false contrast between what the Secretary of State does and what a local planning authority does. Both have administrative functions for deciding the matter of discretion whether or not planning permission should be granted. Both have to act fairly. So their procedure is obviously different, but in each case there can be a dispute about whether planning permission should be granted. True it is the Secretary of State will, if it's a Secretary of State decision, have an inspector's report which the Secretary of State can refer to. Local authority members have an officer's report which they can refer to. And they can do what the Secretary of State often does in his decision letters, which he can say whether or not he agrees with the inspector's report and identify where he disagrees. And in some cases, it's important for members to do that. One of the cases in the bundles, Young, an Oxford City Council, is worth looking at. There, what actually happened is an illustration why you can't, it's dangerous simply to assume that members agree with what officers are reporting. The case came in front of Mr. Justice Ousley. He thought that the members had agreed with the recommendation which they had on the basis of in the officer's report. The case went to the Court of Appeal, but meanwhile, the members revealed what they'd been thinking. And although Lord Justice Pill said that he would come to the same conclusion as Mr. Justice Ousley, that they went on one basis, the members, what members said showed that they had gone on a different basis, and that revealed that they failed to have regard to a material consideration, which resulted in the decision being quashed. So it's actually desirable, if members agree with the officer's report, they should actually say so. I mean, it's perfectly straightforward. You can grant the permission for the reasons given in the officer's report. If the position is that the bits that they don't agree with, they can identify those and, with the help of officers, vote on what they are. One should be aware that under the local government legislation, any question which arises at a meeting has to be determined by a majority of members voting at it. So that would be how one would need to deal with that. But that shouldn't be an impossible task. Your Lordship, I haven't got time to take it to, but can I invite you to look at Lord Justice Swinton Thomas's judgment in Matson about the alleged difficulties of getting 24 aldermen to agree on the reasons given. And,
that was cited by someone.
Yes, I've cited it in my case.
Oh, you cited your case.
But have a look at it. There's that. So, but I don't think that the nature of the function which Secretary of State and the local authority are performing isn't different. In fact, the Secretary of State deals with the application as if made to him in the first instance anyway, apart from calling him. In my submission, there's nothing unduly onerous. If you're concerned about it, the planning is an area which doesn't come under what are called executive arrangements in local government. I'm not sure if the committee is familiar with this. There are different ways in which local government operates, and you can operate executive arrangements where effectively one party controls the decisions and you don't have to have balanced committees. Planning, even if you're operating executive arrangements, doesn't fall into that category. But where executive arrangements do exist, members have to ensure that reasons are given for their decisions, whether they're given in committee or whether they're taking them by themselves under the relevant legislation. So there's nothing inconsistent with requiring members to give reasons for that. If you'll just bear with me, if I can just give you the reference, I think is volume 1. It's tab 12 in volume 1. If you go to page 1095, these are the local authority executive arrangements, meeting and access to information regulations. If you can just look at the definition, decision maker means a decision-making body by which, or the individual by whom an executive decision is making. The decision-making body means the executive, that's the elected members, or a committee of the local authority executive, which again is elected members. And then the requirements, page 1098, where decisions are taken at meetings, as soon as reasonably practicable after any meeting of a decision-making body, which an executive decision was taken, the proper officer, or if the proper officer is not present, must ensure that a written statement is produced for every executive decision, which includes the information specified in paragraph 2, and that includes at B, the record of the reasons for the decision and details of any alternative options. And similarly, if they're taken by individuals, at page 1099, Regulation 13, again, it's the same requirement at 2, B and C. So it's perfectly normal for members to have to produce reasons for their decisions in local government law. Sorry, you wanted, sorry, I've now lost the two stickies. Sorry, where they went. Sorry.
You're nearly done, Mr. Howell.
I am done. Mr. Westaway was telling me that there may be something I need to deal with, otherwise I was going to say I had my time. So, what will it do? It's just Mr. Nedway wanted me to emphasise that other people are going to do the delivery, not the second appellants, and I think that's clear.
Yes, I think we had understood that, yes.
Unless there's anything further that I could assist the court with, those would be my submissions.
No, thank you very much, Mr. Howell. And I imagine, Mr. Westaway, you don't wish to follow? I'm not stopping you. Yes, Mr. Harris. Mr. Cameron.
Thank you, my lady. A number of hopefully very quick points. First, in response on the incorporation of the principles from the Aarhus Convention, Mr. Howell takes a point that the Aarhus Convention refers to reasons rather than main reasons. However, Regulation 24(1)(c)(3) refers to main reasons, and that reflects Article 9 of the EIA directive in its form as amended following the changes made to reflect the Aarhus Convention, and that is the 2003 amendments are at AB1, tab 16, page 1125. So it's the main reasons which the directive requires. Secondly, in relation to, again, Article 9 and reliance on Solvay, which is Authorities Bundle 3, tab 56, and page 2133, particular reliance is placed upon paragraph 59, and there's and reliance is placed on the second sentence in 59, where there's a reference to a full knowledge of the relevant facts. And my submission in relation to that is the determination as to whether a person who wishes to challenge and therefore to understand the basis on which the decision was made, the full knowledge of the facts has to depend on the circumstances. And in this case, one has to look at the officer's report and minutes together, and that is both June and December. So the full knowledge, the facts do not have to be set out, in this case, in the minute itself. I respond on McCrae, which is Appendix Bundle 2, tab 30, paragraph 28, where there's a reference to the paper chase. In this case, although we have turned many pages and looked around, in fact, if one goes to the December committee report, anybody going to the December committee report, which is in the appendix part 2, can see at paragraph 1 reference back to the minutes and the earlier officer report. So, say the report and minutes are appended here too. So you have everything that you need in the December officer's report, which appended the June report and minute and the minutes of that decision. So there isn't a need for a great paper chase, although it may seem like there is at times. In relation to Richardson, which is at Authorities Bundle 2, tab 44, the one point which is taken is that this decision was made before certain amendments had been made to the directive. It's taken in the written case of the respondent. But I would wish just to draw attention to page 1743, paragraph 12, the wording of Article 9.1 under consideration, there does require the main reasons and considerations on which the decision is based to be provided. That which is missing or was later added is more accurate description, is to be found by turning, it's added to the directive, but it's also included in Regulation 24. So the easiest place to find it is in Authorities Bundle Appendix 1, tab 11.
Page
1094, my lord. And what was added wasn't in the former regulation are the words including, if relevant, information about the participation of the public. So that is the change that was made, but in my submission it makes no material difference to the reasoning in Richardson. And Richardson, in my submission, can be relied upon, even in the light of the European cases which have been referred to. And I rely in particular, already referred to it, page 1751, where Lord Justice Simon Brown is quoting from and then approves and agrees with the first instance judgment, and in particular paragraphs 50 and 52. Turning to the submissions that Mr. Howell made on the facts, I would urge the court to be mindful of placing too great an expectation on members of planning committees. And in making that submission, I rely in part on the observations made by Lord Justice Sales in Oakley in the Court of Appeal, and I will just turn, if I can, to the reference for that. I'm not going to read it out, so it's Authorities Bundle 2, tab 39, and it's paragraph 76.
Page?
Page 1682, my lord. If too great a burden is placed upon members who seek to take a different decision from officers, and that they then end up having to write a 30-page screed of the type referred to by Lord Carnworth, that may have the detrimental effect to which Lord Justice Sales refers. Finally, in relation to this particular case, I place particular reliance upon both committee reports and the minutes of the June meeting, but in particular on the December committee report, because the officers placed before members a recommendation that, and I've taken the court to it before for reference, it's the appendix, part 2, tab 3, and in the electronic version, page 611 and P361 for the paper copies. It was a recommendation that the application be approved, and therefore the members were entitled to adopt the reasoning, which is in effect what they did. And in particular, that set out at paragraph 144 and 145, which drew to their attention the requirements of paragraph 116. And in terms of the screening, Mr. Howell seeks to place emphasis on the fact that there was little opportunity to moderate the impact and minimize the harm. But that was quintessentially a matter of judgment for the members. And that is the judgment that they made, no doubt taking into account the view expressed by officers that there was little opportunity for screening to be effective, but they formed a view, and their attention was specifically drawn to the structural landscape area which was provided for in the planning obligation. That is 144, the last passage. So, in my submission, there is no complex paper chase. There is this report. The report does recommend that the application be approved, and therefore the reasoning can be clearly discerned from that report together with its appendices, which include the first report and the minutes. Now that, I have to accept, it does not deal with every single issue of fact and provide a reason, but in the context of a decision by members at a planning committee, it met the relevant standard. I'm conscious that I don't want to take up any more of Mr. Reid's time, so unless there's some specific point, those are my submissions.
Could I ask a question?
Of course.
Very quickly. We were referred to the LLG protocol, and we were told that Dover had signed up to it. You haven't mentioned it, and that is because you don't disagree with the bullet points about good practice contained in it.
No, I don't seek to argue that they're anything other than good practice.
Thank you.
And what I would submit is that the members in the minutes did exactly that. They set out the planning reasons for disagreeing with the officers. They took a different view on the risks to the scheme based on the viability information provided.
Thank you very much.
Thank you, my Lord.
Rules, can I deal firstly with the issue of practicality? Because this decision, a decision of this sort of nature, if there's a requirement to give particular reasons by members of a committee, it will inevitably, my submission, result in a delay in the decision-making process. Because Mr. Howell's case is not simply that one needs to deal with the principal issues, but also the issues that have been raised by third parties. And the sort of report that requires those issues to be dealt with, it would be extremely long. And it couldn't be a report that is produced before the decision in question, because that would be predetermining the application. It could only happen afterwards, or as part of the decision-making process. So there would either have to be a long time spent in committee or a delay for reasons to be formulated and then subsequently ratified, which in my submission adds to the weight of Mr. Cameron's submission.
I mean, here there was a delay. I mean, in practice there always is, but because you need the 106 agreement and so on. So there's always a period of negotiation. I mean, what would be wrong with a decision in principle that they were minded to prove the development, wanted more time, more help on this critical issue of viability and the difference between the Smith Core and BNP Paribas?
Well, the
you
difficult...
didn't get your decision until December the following year.
Well, the difficulty with formulating a decision is that there would have to be a period of consideration as to what the particular responses are on the issues in question. And we're dealing here with issues that were of some complexity and needed to be resolved. And that would all have taken a significant amount of time, a time that, in my submission, would add to the burdens not just on the members themselves, but also officers in assisting members, all of which goes to the point made by Lord Justice Sales and Oakley as to the chance of that dissuading public-spirited members from becoming involved in the process. But so I say that that would introduce not simply inconvenience, but also delay as well. Can I deal with some of the factual points that were raised by Mr. Howell? Mr. Cameron has said that as a generality, the December report dealt with a number of the points, but I go a little further than that, and I say that, in fact, the December report provides an understanding of how the members addressed the particular issues that Mr. Howell relies upon. Can I deal with those in turn? Can I ask the committee, please, to take up the second part of the appendix to the Statement of Facts and Issues? And within that, page P357. An electronic page 607, Mr. Cameron tells me. The first point that was made by Mr. Howell was that in the original June report, there was a simple balancing exercise, no incorporation of the exceptional circumstances test. But if one looks at paragraph 145, one can see the exceptional circumstances test being applied directly and engaged with, necessarily, endorsed by the members when they came to agree the contents of the report. I should say, in passing, in my submission, there's no lack of clarity in the minutes themselves, save for the one word that was referred to earlier on by Mr. Cameron, namely two words, subject to the committee being satisfied. I say it's clear that they were satisfied and the minutes can be read accordingly. But nevertheless, that point made by Mr. Howell that there was a simple balancing exercise applied can be shown to be wrong by virtue of the later decision. The second point relates to the mitigation, which Mr. Howell says wasn't properly dealt with for a number of reasons, one of which was that one needed to understand what was being identified as the nature of the screening in question. Now, there was an EIA in this case, and there's been no suggestion by the respondents that the EIA was defective. And the EIA was required to set out that sort of issue. As to the reasoning relating to the degree to which mitigation would be effective, of course, ladies and lords, have been referred to the June 2013 minutes, which said that there was the potential for effective screening. Well, that was returned to, as Mr. Cameron has pointed out. He's referred to the part of paragraph 144 above 145 in the context of there being then an indication of what was in the committee's mind, namely the potential for effective screening. Now, there's a reference back, actually, within that part of the paragraph to paragraphs of the officer's report. And rather than take up the time that I have, I'd ask lords and ladies to look at those paragraphs, but that takes one back to the landscape analysis. And what one sees in the landscape analysis was not simply that there was to be screening, but it was largely ineffective, not that it was wholly ineffective. So there was the potential, and I should say, this is not a rationality challenge, it's a reasons challenge, and the committee were entitled to reach the conclusion, being aware as they were of the locality, as to the degree to which they would agree or not with what was ultimately said there. But as Mr. Cameron has said, the committee, on the face of what is said in that paragraph, agreed with the officers. It's just that they relied on the potential for some screening in the circumstances, which of course chimes with the overall conclusion that on balance there was a justifiable case to grant permission here. The next point relied upon by Mr. Howell was the potential to increase density that was relied upon by officers in the June 2013 report. And if lords and ladies could please turn to that report again. The relevant page is at 492 of the electronic pagination in the second core bundle. And if it's right that one applies a Porter test, one is only required to deal with main controversial issues. And what the officers there set out was the anticipated scope which the committee might consider which might exist to increase residential density. So might consider. It was in no way put forward as a principal issue that was required to be considered by the members as part of the determination process. The next point is the reduction in density. That one can see answered by virtue not simply of what has so far been set out by Mr. Howell, but also by what is said at 2456, page 492, pagination, electronic pagination, again, of the officer's report. Because the issue of the reduction in density was allied to the degree to which one would safeguard part of the area for development. And there was a conclusion set out which identified that there had been previous discussions between CGI and the officers, because one could see that at the start of 2456, discussions over the course of the submission, the conclusion being that the issues being put at risk, including the safeguarding of a particular area, which is at point 2, which necessarily took into account the potential for reduction in density. So again, that was dealt with specifically in my submission. The last point relied upon was the hotel. Again, 2456, for the reference, shows that that point was part of the gamut of issues that were taken into account for the purposes of concluding that there was here a development that would be put at risk. So for those reasons, each of the points that were relied upon by Mr. Howell as needing to have been dealt with were dealt with. Again, this is not a rationality challenge, it's a reasons challenge. And so long as there was a basis upon which the committee was entitled to reach conclusions, that should be enough to satisfy the reasons duty. I've cantered somewhat through those various points, but Honours and Ladies will hopefully forgive me for that. Those are my submissions, unless I can assist you.
Thank you very much indeed, Mr. Mayor. Thank you.
I'll delay the court for one more moment. Lord Carnworth asked earlier about the Code for Sustainable Homes. And if the court would like it, we have a short extract from the guidance on the Code for Sustainable Homes, which has been subsequently replaced by a different system. But this extract explains the criteria taken into account. So perhaps if we could hand that in a moment.
Thank you very much.
Thank you. And thank you to everyone for all their submissions, both orally and in writing. And we shall take them fully into consideration, and we will provide reasons for our decision at what no doubt most people would consider inordinate length, but I hope not in an inordinately long period of time. We will let you know in the usual way. Court is now adjourned.